Sight and sound. The implications of copyright on recording images and sound. I'm Mike Sarayan, answering some questions about copyright. What does copyright mean? Intellectual property is a general term that covers several areas of law. Copyright is one of these areas. Copyright does not protect ideas or information. The use of a name or logo can be registered for a fee as a trademark. This protects against others using a similar mark in the course of trade. A design may be protected in relationship to its appearance or shape, but not functionality. Patents protect new, innovative, and useful inventions, processes, methods, and techniques. Patents, designs, and trademarks may be registered with IP Australia. Copyright protects the way ideas or information are expressed, but not the ideas or information themselves. For instance, documents and drawings may be copyrighted, but not the ideas contained in those drawings and documents. Something is protected by copyright if it is a form of expression covered by the Copyright Act. It is recorded or fixed, written or saved digitally, and is the result of some skill or effort, not just copied. To be protected by copyright, the work must be first published in a country that is party to international copyright treaty, or by a national of one of those countries. Things you can copyright: directories, databases, computer programs, games, songs, advertising, dance, mime, paintings, photos, crafts, graphic design, buildings, logos, engineering drawings, plans, maps, charts, sculpture, jewelry, films, TV show, animations, drawings, musical performance, interviews, writing, typographic design, and of course lots more things. Phew! Copyright does not protect ideas, concepts, styles, techniques, or information. For example, if you write an outline or script for a TV show, the text is protected by copyright. Someone wanting to reproduce it would need permission. However, if someone uses your ideas to create their own script, they may not be infringing upon your copyright. Copyright becomes an issue if they copied an important or distinctive part of your original work. Copyright holders can sue for infringement, and the court may order compensation and court costs be paid. You may be sued or charged by the police for authorizing infringement, helping or asking someone to violate copyright, renting out or selling copyrighted material without permission, decoding encrypted material, removing or altering rights protection, failing to attribute authorship of a work, changing work in such a way that it becomes offensive to the creator, or recording a performance without consent. Piracy is copyright infringement on a commercial scale. Certain forms of expression, including text, photos, music, film, and computer programs are automatically protected under the Copyright Act. If your work is artistic, the result of some skill or effort rather than copied, and it is recorded or fixed to paper or digitally, no action by the author is required. It is protected as soon as it is created. We are all familiar for the notice for copyright. However, this is not required for something to be protected. The notice does inform people of who holds copyright and the date it was established. For dynamic works, such as a website, copyright can nominate a range of dates. Copyrights may be held by individuals or corporations. So, if I work for Bill and he asks me to design a new logo for him, who holds the copyright? Bill holds the copyright. If Bill hires me as a freelance photographer to create an image for him, who holds the copyright? I do. Bill will not hold copyright, but can use it for the purpose for which it was commissioned. Bill paid for a recording studio for me to record my song. Who holds copyright? Bill does, unless he offers to share copyright. The owner of copyright in film or sound recording is usually the person who paid for it to be made. Copyright can be transferred by assignment, can be held by more than one owner. Copyright permission must be received from all holders of the copyright.
Get up. Shit, man. Get up. I know you're not hurt.
What? I only used a little part of a copyrighted work. You may need copyright permission if you use any important part of the work, no matter how small. You might infringe on copyright if you produce something that strongly resembles the copyrighted work. Copying the combination of incidents in a dramatic work, while using new wording and dialogue, may infringe upon copyright. This claim was used in a lawsuit against the publisher of the Da Vinci Code. There is no claim to be made if the work is based upon stock incidents or characters. There is no copyright infringement if the person making the similar work has not seen or heard of the copyrighted work. it's a coincidence. The Copyright Act contains special exemptions that allow the use of copyrighted material without permission. For example, for use as research or study, if the use is fair. Private use and non-commercial use is allowed under specific conditions for specific purposes. Some institutions are covered by licenses from copyright owner organizations that allow them to make uses of music not covered by the special exemptions in the Copyright Act. The organizations are the Australasian Performing Rights Association, Australasian Mechanical Copyright Owners Society, Australian Recording Industry Association, Phonographic Performance Company of Australia. Under fair use, what is an insubstantial proportion? For hard copy editions of literary and dramatic works, no more than 2 pages or 1% of the total number of pages in the edition may be reproduced. For published literary and dramatic works in electronic form, no more than 1% of the number of words in the work can be reproduced or communicated. You usually need a performer's consent to film, record, broadcast, or communicate a live performance. You usually need a performer's consent to film, record, broadcast, or communicate an unauthorized recorded performance. In some cases, you may need a performer's consent to use an authorized audio recording of a performance. What are the rights and restrictions of artists who record an image of a person, building, or landscape? Are you an employee? If you are being paid by someone to create an image for their use, they own the copyright. If you are an independent contractor, they must negotiate with you for the copyright. If you are being paid, are you, in turn, paying others for their intellectual property? For a musical case study, let's look at one of the musicians in Men at Work. He played a key instrument in a #1 music video in the UK, Australia, and America, but used a riff that seemed familiar, even though he didn't care or know where it came from. Quote, "It could be from Waltzing Matilda, or from What Do You Do with a Drunken Sailor for all I knew or cared," Greg Ham said, talking about the hit song Down Under. Quote, "I then came up with what I thought of as an Aussie cliche melody. It sounded Australian," unquote. Coincidence? In the video, he sits in a tree next to a stuffed koala. The riff comes from a children's folk song, Kookaburra Sits in the Old Gum Tree. The copyright is now owned by Larrikin Music Publishing in Australia. They are suing EMI and the authors of the song, Greg Ham and Ron Streichert, claiming they produced more than half of the original song. Larrikin Publishing wants between 40 and 60% of the income earned in the future and for the past 6 years. That is as far back as the law allows. EMI claims that the use was unconscious and a fair adaptation under the Copyright Act. Australian Federal Court will decide. Professor Jill McKeough, who's Dean of Law at the University of Technology, Sydney, said, "There is an old saying, quote, where there is a hit, there is a writ, and nothing is truly original. There are so many songs in the world." It's all very complicated. In the legal world of trademarks, patents, and copyright,